everyone, welcome to Newcastle for a lovely Thursday evening. My name's Josh Normanton, this is Shada Mellor.
Hello.
We're barristers here at Trinity Chambers, and this is a talk about what happens after confiscation. So after a confiscation order is made, or perhaps not made in the case of my talk, what happens when the prosecution wants to reconsider that confiscation order, or what happens when they want to enforce it. I'm going to start by looking at the question of reconsideration, and with that in mind, perhaps we can go to my first slide. For defendants, particularly those involved in serious organised crime, drugs and fraud, the prospect of the reconsideration of a confiscation order, particularly a reconsideration of the available amount, is the legal equivalent of a sort of beating telltale heart under the floorboards. After all, winning a trial is great, but the next best thing is persuading the court that the available amount is far, far less than the benefit. But long after perhaps the high of that outcome has dissipated, and often long after a prison sentence has finished, a terrible truth can become apparent. That is that confiscation orders, unlike perhaps sentences, are not necessarily final. There is legislation in place, which I'm going to take you through, which seeks to, well, really what the legislature is seeking to do is address the possibility that defendants have not been entirely honest about their assets at the point of the original confiscation order, and also take into account that there may be changes in a defendant's life which puts them in a position to pay where they might not otherwise have been able to. One thing we may want to think about reconsideration is that financial crime investigators are becoming even more resourced as time goes on, probably because they're obtaining more reconsiderations and confiscation orders. Unsurprisingly, financial crime investigators struggle to forget confiscation orders that they don't think went in their way, and they are vigilant. And while practitioners will have noticed an increased focus on account freezing and forfeiture orders in the POCA space, reconsiderations are also another form of pretty low-hanging fruit. It's not really often difficult to work out whether a defendant owns property or has more money, and the effect of that is we're seeing a general increase in reconsiderations, and one suspects that trend is only going one way. So it's in that context, it's hoped that this seminar helps you understand the law arguments relating to reconsiderations with perhaps some helpful thoughts on strategy based on my experience of arguing reconsiderations and variations over time, both as a prosecutor and a defender. Perhaps we can start with some real basics as a refresher. Confiscation orders are orders designed to confiscate the proceeds of crime from criminals. Almost all the applicable legislation is set out in the Proceeds of Crime Act 2002, which almost all practitioners call POCA. Part 2 of POCA sets out the process by which confiscation orders are made. And in very general terms, once a person is convicted, and if the prosecution asks the court to do so, the court assesses what a person's financial benefit from crime is, and separately how much they have to pay, and makes those orders. The court might differ in its approach depending on whether someone is assessed as having a criminal lifestyle or whether they've just made money from their specific criminal conduct. I'm not going to go into those concepts in great detail today. But what practically happens is at the end of the Crown Court process, usually long after the sentence is imposed, a confiscation order is made, sets out the total benefit and the available amount. And if the defendant pays the available amount, usually within 3 months, then they may well think that's the end of it and they can breathe a sigh of relief. That is until the sequel, which no one really wants, which I'm going to talk about today. I wonder if I can go back a slide and start looking at that. Confiscation orders are near unique in that they are capable of amendment long after they've made. In some cases, as you'll hear, often many years after. One thing we can certainly take into account about confiscation orders and reconsideration is that POCA does not really care if people have moved on and doesn't really care about rehabilitation. So the first point on this slide is I've just set out the various different ways to alter a confiscation order after it's been made. There are a handful of other different ways, including a specific section that applies where a defendant has absconded before the order was made. I'm not going to deal with those today, but would be happy to field emails and discuss those if anyone was interested. Most clients are concerned with Section 22, which concerns the reconsideration of an available amount, and it's more frequent that you will see that section come into play than perhaps the other sections. But there are also other methods by which benefit can be changed. And indeed, there are methods by which a case in which no order was ever made or no order ever pursued can turn into a confiscation order. So there are three types of reconsideration which could lead to a change in the benefit figure. These are under sections 19 to 21, so the first three in my table. What approach is taken with those, as in which section you choose, depends on what happened in the original proceedings before the Crown Court. Then there's reconsideration of the available amount, section 22, more common, and the effect of which is usually more immediate and impactful on a defendant, and that's why it's attracted the excitement of an exclamation mark. There are similar provisions which lead to significant changes in the original confiscation order. One of the provisions I'm going to talk about is the variation of an order brought by a defendant under Section 23. Not quite reconsideration, but similar principles apply. In the pursuit of completeness, there are three other provisions which could also lead to changes, variations, reconsiderations of the order after the fact. Those are in sections 24 to 25A of POCA, generally designed to allow a magistrates court officer to apply to the Crown Court to discharge the order in certain limited circumstances. But as those relate to the role of a magistrates court officer, and you may never have to think about them again in your entire practice, I'll move on. So I turn to my next slide. What I want to do is examine the reconsideration of benefit first, and you will remember that those can occur under sections 19 to 21. The underlying principles for reconsidering benefit under those provisions are largely the same, and I'll come on to those shortly. The first two sections, 19 and 20, can lead to entirely fresh confiscation orders in circumstances where really no order was made. Section 19 applies where someone could have received a confiscation order, but for whatever reason, including perhaps illness, the Crown did not pursue it. It isn't perhaps an uncommon situation where the Crown take the view that a client, for example, has no money, and there's no point in wasting the expenses of conducting a financial investigation, and then subsequently they change their mind. Section 20 applies where the Crown pursued a confiscation order, but the court decided that the defendant didn't benefit, and then again the Crown may change their mind. Section 21 applies where the court made an order, but the prosecution thinks it can prove that the actual benefit now is higher than it was in that original order. In other words, you made more from your criminal enterprise than perhaps we first realised. Each of those sections contains provisions which allow the court to approach the calculation of a confiscation order in a particular way. They allow the court to make certain assumptions about what happened prior to the original conviction date, but importantly, they all also allow the court to take into account any property on or after the conviction date if it was obtained as a result of or in connection with criminal conduct occurring before the conviction, and the aim of that is obviously to target additional benefit. But unlike a normal confiscation order, particularly where the assumptions apply, as in where someone has a criminal lifestyle, it's it's more difficult to prove under these reconsideration sections. I say that because those sections provide that certain statutory assumptions do not apply after the conviction date. And what does that mean in real terms? Well, essentially, the court is not allowed to assume that the property that the defendant obtained after his conviction is a result of crime. And to that extent, and to that limited extent, he's wiped his slate clean, and the Crown needs to prove that it is related to his original criminal offending. So the sections allow the authorities to either target benefit they did not know you had, or benefit you subsequently obtained that's linked to the original criminal offence. But that benefit is a little more difficult for the authorities to prove because of the lack of statutory assumptions. After that fairly hefty preamble, I'll turn to the content of the slide. These sections are not sections which the authorities can simply apply under whenever they feel like it. They need evidence. It's not a chance to re-argue the old confiscation order on the basis of the evidence they already had. It must be brought on the basis of evidence which was not available to the prosecutor when the defendant was convicted or made their previous order. One might reasonably imagine that the first thing your client may say to you when you explain that test is, well, the police had this information at the time. My view of it is not available. Means that effectively the prosecution were not in a position to obtain that information from the police. Generally, the police did not have it. So it is broader than simply not being in possession. When the prosecution apply with that evidence, the court has to consider the evidence to decide whether it's appropriate to proceed. And then if it is appropriate to proceed, the court then goes on to make the calculation of the relevant amount. As I said, under sections 19 and 20, the court is effectively just considering a confiscation order anew. But under section 21, if the court's new benefit figure exceeds the available amount previously assessed, then the court will be assessing benefit and also assessing the available amount again, in effect looking at the confiscation order anew. So in all of these cases, it's often the case that not only is there the considerations of benefit, but also one is looking at reconsideration of the available amount. But here is where orders for reconsideration differ. It's where the court looks at what's recoverable. Rather than, as we may know under confiscation orders, the court is just requiring you to pay whatever you have available. Here, the situation is slightly different. The recoverable amount, the amount you have to pay, will be what the court considers just. That's something different to what's generally assessed under section 7.2 of POCA, which is where the available amount is. Now, in the hope of squeezing as much cinematic suspense one can hope for in a talk about the reconsideration of confiscation orders, I'm going to return to that test after dealing with section 22. Simply because that contains the same test, and it's very useful to look at it in isolation, because it's in that test that really defence lawyers can do perhaps not wonders for their clients, but there are points to argue. The final point I make in relation to the prosecution's power to reconsider benefit under these sections is that they're time limited. 6 years from conviction, the prosecution must apply in that time, and so in that sense there's a degree of finality after that 6 years has elapsed. So I wonder if I could turn to my next slide. So there's finality unless your client comes into funds, wins the lottery, or inexplicably starts driving around in a Ferrari, or pays off his available amount, but somehow wonders never cease, ends up still living in his property. Then if he is unlucky or perhaps short-sighted enough to attract the attention of the authorities, they may well apply for reconsideration under section 22. And in this regard, there is no time limit, nor is there any requirement for fresh evidence. It is not a particularly difficult application to make. and effectively what it requires of the court, where there's still an outstanding amount of benefit, is the court has to make another assessment of the available amount as it would under Section 9. In doing that, what the court has to do, so if the financial investigator, the POCA unit, goes back to court and asks them to look at the available amount, what the court is not doing is just looking at the available amount that's arisen since conviction. It's looking at the entire available amount that's then available to the defendants, the total free property available, less any relevant preferential debts and things of that nature. It also means the court's looking again at things like tainted gifts. So if a defendant has made large unexplained gifts of cash to someone since conviction, well, that's relevant. If the defendant has his home, he still has his home and someone else perhaps has paid it off, his confiscation order off, well, that's still relevant. If property has gone up in value, that's relevant. And in that regard, there's a useful case called Crown against Nicky Wood, a 2022 case in which there's a very helpful judgment from Lord Justice Stuart Smith on that very point. And if the new calculation exceeds the available amount, the court then is entitled to require payment. But again, it must impose such amount as appears just, and I can feel the suspense building before I deal with that. So years later, your client is reassessed for the available amount and is required to pay. Even years later, default terms can still be applied. So this is a serious application with serious consequences. And as I said, no time limit. The test of what the court considers just is certainly better in principle than automatically being fixed with the entire available amount, because it gives room for manoeuvre. And indeed, there are other elements of reconsideration which are sometimes better for defendants. When we're looking at the application of statutory assumptions is a good example. And any advocate is naturally attracted by the opportunity that discretion provides. And where in these sections the statute says that what matters is what the court considers just, there exists that attraction and room for manoeuvre. Well, what is a just order? Part of what it involves, so the more boring part, involves having regard to other orders, and I've listed them on the slide, and they're contained in the legislation. It doesn't quite say that they'll take precedent, but it seems to me that a just order is rarely going to be appropriate if it ignores them. But I say that's the more boring, straightforward part. What else? Is it just where a defendant obtains loans to pay off his available amount in his confiscation order rather than sell his family house for his family house to be assessed as now available? To some that may seem very unjust because he's placed in further debt and his living circumstances and potentially those of his family are placed in another round of jeopardy. What happens is it just if a defendant receives a personal injury payment? Is that something that can be reassessed as part of the available amount? What if he has worked very hard day after day since getting out of prison in legitimate work and has built up money that way? Is it just to invite reconsideration then? Perhaps reflecting the draconian nature of POCA, all of those situations are potentially just, and I'll explain why. The test is not what is just to the defendant, unfortunately. And what I've referred to here is legislative policy. And the case of PADA, but the point remains in many other cases. When you're interpreting what to do in POCA, often the authorities say, well, what matters is the steer that POCA provides. And I'm just picking a few quotes from Supreme Court authorities. The overall aim of the statute is to recover assets acquired through criminal activity both because it's wrong for criminals to retain the proceeds of crime and in order to show that crime does not pay. Or Lord Walker in the case of Weyer, purpose is to impose upon convicted defendants a severe regime for removing from them the proceeds of crime. So what is just needs to take that into account, and often it's the default position, starting position for many courts, that a person should be required to repay the full value of their benefit, even if it causes them real financial difficulty now. Not quite the final word, though. There are some matters which are relevant to the assessment of what is just and can be used as arguments on the defence side. The Court of Appeal has said that the passage of time can be relevant. It says that in a case called Crown and Mundy, 2018 case. But I think the passage of time needs to be quite significant. Padder, for example, took place 6 years later. Another case called In re Peacock, these are all cases in which reconsideration was ordered, took place 10 years later. Source of income is relevant. The appellate courts do seem to distinguish between cases in which you've got sort of lottery windfalls, there's going to be reconsideration there, and cases where you've got sort of legitimate income, money obtained from hard work. A case called Leon John, 2014 case. What the court said there is when you haven't got those windfall gains, the court really needs to anxiously consider the competing considerations. A good submission, in my view, is that it begins to become unfair for a defendant who's legitimately obtained monies in a crime-free way for many years to eventually be reduced back to stage one again. And third-party interests, again, in my view, must be relevant. If there's an impact on third parties, a serious impact on third parties on effectively requiring a full reconsideration, families, perhaps other people who've provided loans, and those can be things that can be relied upon. But in many cases, this is a system which is harsh. That's the point, and it'll be a challenging argument you'll have to make. Turn then to my final slide, which is in relation to variation. So it's not reconsideration, which is generally to the detriment of a defendant, but variation, which can really be to his advantage, can be made by an application could be made by the defendant or an enforcement receiver. Generally, if it's the enforcement receiver making it, well, defendant generally is well advised to just agree. But there will be situations in which clients will come to solicitors, often at the end of their wits, and say, I just can't pay this order. What can I do? And usually that may well come before the default term begins. It may come long after, and it just doesn't go away. Not wanting to ruin the main theme of my talk, these applications are really tough, but they can succeed if they're well argued and well evidenced. In deciding what to advise a client, in developing such an application, it's a good idea to have in mind what the court will require. An applicant has to prove not only that the available amount is less than previously, but also that the court should exercise its discretion to impose a smaller amount as is just. So we've got that word again. I've referenced the problem raised by cases called Gockall and Eunice. Eunice applies to these specifically to this section. This is not an appeal, and you can't relitigate matters that have already been assessed as part of the original confiscation order. So you're stuck with the decisions that were made as part of the confiscation order last time, including decisions about hidden assets. What that means in practical terms is where a defendant is saying that I don't have the money, he needs to explain to the court what's happened to those hidden assets, and that obviously is very difficult to do. Perhaps more generally, perhaps it's difficult to do in a credible way. It's a more possible application where the available asset has gone because of dissipation, change in the value of money, theft, or some other operation. So where defendants are applying for variations years down the line, having served their default term, and just say, well, but they had hidden assets orders at the start. It's not enough to say, well, look, time's passed and I'm not able to pay. They have to be able to explain why. And it's difficult for courts to accept that the hidden assets don't exist somewhere unless there's some sort of credible evidenced explanation as to where the available amount has gone. And there have been cases that I've been involved in where I've made these applications, and it seems to me the defendant's in an impossible position. And if he could have paid, he would have paid, and he just doesn't have the money because ultimately the way the available amount was assessed at the start was not to his benefit. It has been difficult to win cases like that, and part of what the authorities say, none of which are particularly helpful to defendants, is that even assets which are difficult to realise for whatever money are still realisable property. How you'll proceed in those cases in advising and representing will often depend on what happened when the original order was made. It's complex and hard if there's a criminal lifestyle finding or findings on tainted gifts. And unless a client is in a position to explain everything, one has to be realistic about the merits. So that is a course through reconsideration and variation. I'm going to pass over to Shada now to do her part of the talk.
Thank you, Josh. Moving on to my part of the talk, which focuses upon enforcement. Here the slide is key provisions, similar to that which Josh has taken you through. However, this features the specific sections which will feature throughout my talk to you. Firstly is section 11 of POCA, and that concerns time for payment. Of course, the relevance of this is, apart from compliance orders, which I will turn to in the next slide, really enforcement action begins after the time for payment has expired. The default position is that the full amount of a confiscation order should be paid on the day that the order is made. However, the court can initially allow a person subject to such an order 3 months in which to pay. There is then a further provision that a further 3 months can be provided. On making such an application, the application must be made to the court before the expiry of the first 3 months, and the person must show that all reasonable efforts have been made to effectively pay the confiscation order. Whilst the application must be made before the expiry of the initial 3 months, it can be heard after 3 months. I'm sure most of you are all aware of the strains that are on the criminal justice system and the difficulties in obtaining hearings. What is central, though, is it is not in a further 3 months being granted, so a total of 6 months. It is not from the point that that further 3 months, the hearing to allow the further 3 months is granted. The total amount of 6 months must be from the date of the confiscation order. Turning then to compliance orders, this is contained in section 13A of POCA. A compliance order is very much what it sounds like on the tin. It's an order that the court can put in place to ensure that the confiscation order is effective. That can be made at the time of the confiscation order or at a later date, providing that the confiscation order still has effect. What is notable as well in relation to a confiscation order is that it can be made, in fact, against a third party, and that is set out in the explanatory memorandum to the relevant section of the legislation. Now, in terms of the types of compliance orders, the one that is referred to within the legislation under this specific heading is an overseas ban, that being to prevent somebody from travelling overseas. There is no restriction on what compliance orders are limited to. but the one, as I said, that is referenced in the legislation is a ban on overseas travel. In terms of the test in making a compliance order, it is not one of necessity, but there is a proper reason for making the order. That, in effect, must be striking a balance between ensuring that the confiscation order is effective, as well as the impact upon the defendant or the third party, particularly if it concerns travel restrictions. I've referenced within the slide the case of Pritchard, which is from 2017. And in that, the Court of Appeal addressed travel restrictions. And in that case, the court deemed that a travel restriction in the form of a compliance order was appropriate against a defendant who had been convicted of drug trafficking offences, had international connections, and also had hidden assets overseas, and in that case had failed to file tax returns. Another factor in making a compliance order, particularly again in respect of travel, it is features in relation to the defendant's circumstances. That may be how long is remaining of his sentence and the time to pay in relation to the confiscation order. On the making of a compliance order, both parties have the right to appeal against the making or non-making of the order. Now turning to the principles of enforcement, Section 35(2) of POCA provides that a confiscation order is to be treated as a fine to be collected and enforced by the magistrates' court. Whilst it's treated as a fine, it follows the POCA principles, and this regime is more severe than those applicable to general fines. In relation to what the magistrates can do and cannot do, the magistrates' court cannot extend the time in which somebody can pay a confiscation order. It is clearly set out in the legislation that the maximum period is 6 months. So it would be against that principle for the magistrates to have the ability to extend the time to pay. However, what I will come to shortly is that the magistrates' court do have the ability to issue a postponement of consideration of a warrant for committal to prison. In terms of then the practice, if the amount of interest, if the confiscation order is not satisfied, so if it is still continuing after the date for payment, simple interest can accrue on the unpaid amount. As many of you will know, when the court makes a confiscation order, it sets defaults for payments, and that is the terms effectively from the 1st of June 2015 onwards, and set out within the slide is the default terms of imprisonment. In relation to an amount of £10,000 or less, that's 6 months, 10,001 penny up to 500,000 is 5 years, 500,001 penny to 1 million is 7 years, and more than 1 million is 14 years. And I should say that's up to 14. On an application, if a defendant is in default, the magistrates must issue a summons for the defendant to attend. And whilst I've just referenced shortly beforehand that the magistrates' court cannot extend the time for pay, what they can do is postpone the issue of a warrant for committal until such time and on such conditions it thinks fit. You may think they are very close to one of the same. If a defendant is serving a sentence for a different matter, the magistrate's court can also postpone the issue of a warrant until that sentence for a different offence has expired. And on somebody being committed to prison for the non-payment, this does not mean that other means of enforcement cannot take place. There will still be activities to ensure that the confiscation order is satisfied. And like with many criminal offences, although the regimes have recently changed, when a defendant has served half their sentence, they are eligible to be released. There is a caveat to that, and that is unless the amount of the confiscation order is more than 10 million. When the magistrate's court then come to consider sending somebody to prison for the non-payment, one thing they do look at is whether there has been part payment of the amount of the confiscation order. And if there has been, the period in which the person must serve is to be reduced accordingly. And that is set out in the case of Gibson against the Secretary of State for Justice, a Supreme Court case from 2018, where it is said that the reduction must reflect the proportion paid of the original amount of the confiscation order, not including interest. For example, if a 10-year default period is fixed in respect of an order for 1 million and 50% has been paid, the term to be served is 5 years, regardless of the amount of accrued interest. In respect of interest, the only means of enforcing the accrued interest is through civil enforcement. However, pursuant to section 39 subsection 5 of POCA, the Crown Court can increase the default term where interest has been accrued. So that is one thing to keep in mind and consider if you are dealing with one of these types of cases. We do see cases in which there has been joint obtaining, where each defendant is liable to serve the default, and that cannot effectively be offset for time served by a co-defendant. Within the slide is also referenced a case of Sangria, which is a 2017 case, and that looks at what the court or the magistrate's court must be satisfied of before they commit somebody to prison for being in default. The court must be satisfied before it may commit somebody to prison in these circumstances that the default is due to the offender's willful refusal or culpable neglect. This is not reviewing the confiscation order made by the Crown Court, but what the court should be satisfied of is that there is no alternative means of enforcement available before committing the offender to prison. A very straightforward example of that is if you have somebody who is trying to sell a property and the sale of that property falls through, but the property still remains on the market, it still remains saleable, it would be in that situation that the court couldn't really or shouldn't be satisfied that there had been willful refusal or culpable neglect when a property sale has fallen through due to no fault of the defendant. And when we talk about other means of enforcement, What is not required is a staged process where every alternative type of enforcement needs to be attempted and failed. It is sufficient for the court to have turned their mind to consider the other forms of enforcement and deemed that they are not appropriate or would not work. The position in respect of tainted gifts, it is a little bit more complex and tricky, because by their very definition they are irrecoverable. Even if in practice the person who the tainted gift had been given to may be persuaded to return it, they also may not. But the Proceeds of Crime Act still requires a default term to be fixed where the order is based on such a gift. So the policy still applies in respect of committing to prison if the confiscation order is not satisfied. However, that may be something that enforcement proceedings can assist with. Turning then to enforcement receivers, if an order is not satisfied, the prosecution can apply to the Crown Court to appoint an enforcement receiver. On making the application, the court can confer powers on the receiver to take possession of realisable property, manage or otherwise deal with the property, realise the property in such a manner as the court may specify, and there are also provisions around crypto assets. So recovering those, if they cannot be recovered, for them to be destroyed, and there is also consideration of even if they can be realised, whether it is in fact in the public interest to do so. There are cases, particularly more complex cases, where there is property which is believed to be outside the United Kingdom. In these situations, what the Secretary of State can do is make a formal request for assistance to that relevant country where they believe the assets to be, and on that competent authority agreeing to that, steps can be taken for enforcement and to release that property to satisfy the confiscation order.